So let me welcome all of you to the Zoom session for the NYU reunion. Let me especially welcome alums back to the school. Reunion was always one of my favorite times, and I'm sorry that I can't be with you in person. As many of you know, Helen and I have entered a continuing care retirement community out here in Palo Alto and are living the good life, relaxing out here. I'll be back to teach at NYU in the fall semester to teach a seminar in the religion clauses. And I look forward to saying hello to any of you personally who stop by. The subject of this morning's exercise is the separation of powers issues raised by the Trump administration's first 100 days. And I think it's fair to say that we're living through what I call a constitutional earthquake, maybe a constitutional crisis, but certainly a constitutional earthquake that is comparable to only two periods in our national history. There's only two times that you could think of that are roughly analogous to this. And the first is a sad time. The first is the period between 1850 and 1860, when the country grappled with the moral imperative of ending slavery and was simply unable to use law to solve that awful social problem. And the net result, of course, was the Civil War, 750,000 dead, untold bitterness and loss. Lincoln had it right when he said that if we can't succeed in using law to solve our problems, that creates an institutional vacuum that will inevitably be filled by violence. And that can be government violence from a tyranny or private violence from terrorism and rebellion. And so especially those of us who care deeply about the law and care deeply about preserving what is our nation's, I think, most important resource, and that is commitment to a government under law. Finding ways to harmonize our current social conditions with the rule of law may be the single most important task that American lawyers have today. The second period is more closely analogous, and it has a slightly happier tint to it. And that's the period between 1932 and 1937, when Franklin Delano Roosevelt tried to lead the country out of the Great Depression by doing three things. I mean, there were three basic things that Roosevelt did in those first 5 years. The first thing he did was to remake the executive branch by expanding the activities that the executive would be expected to deal with. You guys remember it from ad law and con law as the creation of the alphabet agencies, the SEC, the FDA, the NLRB, all of the administrative agencies that we come to take for granted these days. Many of them were created during those first 5 years. And it was a revolution, an absolute revolution in the idea of the relationship of the executive to the rest of the country. The executive grew dramatically under Roosevelt. That was coupled by a successful persuasion by Roosevelt to persuade Congress to increase the degree to which they regulated the economy. And so congressional regulation of the economy under the Commerce Clause went from a relatively narrow band of issues to basically anything to do with the economy. You guys remember from con law the explosion of regulatory power that took place during that period. And finally, the Supreme Court eventually, it took until 1937, but the Supreme Court finally accepted the new administrative structure that Roosevelt had put into place, and the expanded regulatory power that Congress was exercising. And the net effect of those three things created what I call, and many other people call, the mixed executive. The mixed executive is this very large, very powerful group of federal officials that are operating to administer the expanded New Deal vision of what the federal government should be. And it had a number of attributes. It was, first of all, a shared enterprise. It was a partnership between Congress and the president. Congress would structure the agencies, decide what they should look like, decide what their regulatory authority should be, but most importantly, also decide how they should be actually structured so that they would have some agencies with multiple commissioners who would be bipartisan and who would serve for fixed terms. And the purpose was to insulate the day-to-day activities of many of these agencies from presidential politics, from the need to move them around in order to gain a short-term political advantage. The theory was that these officials were experts, that you were appointing people to run the Federal Food and Drug Administration, or appointing people to run the Federal Reserve Bank. You were appointing people on merit because they were very, very good at what they did. And you wanted to insulate them from the day-to-day pressures of politics. And so you had what was an unwieldy and theoretically cumbersome operation. It was a very large operation, but excuse me, I'm just getting this strange message. Mixed executive was very difficult to put a theoretical halter on. It was cumbersome and it was fuzzy. Because Congress was in fact sharing some of the burden of administering this new huge administrative apparatus by explaining exactly how the agency should be structured. And the courts made a deal. The Supreme Court made a deal with Roosevelt in the 30s. In return for Roosevelt conceding that the courts would continue to have complete control over legal issues, judicial review of what these administrative agencies were going to do, both the statutory construction issues and the constitutional issues, would continue to rest with Article III courts. But the fact-finding powers, the administrative hearings that were taking place, the courts were granted deference to the fact-finding processes of the administrative agencies. So what you have coming out of the New Deal is this very new, untried structural mechanism where the executive branch was much larger, and it was administering programs far, far greater than anything it had ever tried before, but it was doing so in connection with a mixed set of powers that could only be viewed as a partnership between Congress and the president. The first 100 days of the Trump administration have witnessed a flat-out assault on the idea of the mixed executive. And this is where the separation of powers issues become so important. A flat-out assault on the very idea of a mixed executive, because spurred by this Heritage Foundation 2025 report, the conservative theoreticians argue that the mixed executive is itself unconstitutional, because the mixed executive gives too much power to Congress to interfere with the day-to-day running of the government by a single person and that's the President of the United States. So the unitary executive, which is the system that they are trying to impose on top of and in place of the old Roosevelt mixed executive, is a pyramid in which the president sits on top of this vast administrative operation and has absolute control, day-to-day control over what every single person in the administration does. It is in some sense, the model is a military model. They want to think of the president as a commander-in-chief, and the commander-in-chief issues orders to everybody up and down the hierarchy, and there can be no interference with the control of those orders. Now, the risk. Now, let me, since this is in some sense an academic enterprise instead of a pejorative one. I don't want to get. I don't want to be unduly pejorative. The problem with the unitary executive is that it vests an astonishingly strong amount of power with a single person. In an ordinary time, we would worry about that because the argument would be it's a mistake to risk putting all that power in the hands of anyone. No one should be able to exercise the kind of unitary power over the vast administrative apparatus. In these times, when the power would be given to someone who is, I think, demonstrably incapable of exercising that power in a principled and systematic way, it risks being disastrous. It's a formula for tyranny. I don't know if you guys remember when you took your separation of powers course, but I hope whoever taught it to you reminded you of a saying, famous saying, by a British theoretician, a British political scientist, Lord Acton, during the 19th century. And Lord Acton said, all power corrupts, period. Absolute power corrupts absolutely. And so the risk with the unitary executive is that it vests absolute power in the president. And it's an absolute power that argues that Congress can't help structure and run these agencies. And it also says, excuse me, that the courts have a very limited role in interfering with presidential power. And that's the crisis, I think. That's the earthquake that we're dealing with now. We're dealing with a situation in which the mixed executive, which took the country out of the Depression, through the Second World War, through the Cold War, through the first 25 years of the 21st century, is now under siege from theoreticians and politicians who want to impose a unitary executive. Now, you want to stop for a second and ask yourself, remember, if they succeed in imposing a unitary executive, that would work to the benefit of a Democrat, if a Democrat ever holds the White House again, if we would ever hold free elections again after that. A Democrat would have the same kind of unitary power that President Trump is trying to assert now. So it isn't as though this is a set of powers that can be applied only by a single political party in a single time. As a matter of theory, it empowers any president, including a Democrat. But at this point in time, it risks empowering someone who is, I think, demonstrably unqualified to exercise those powers and creates a serious threat to whether or not the rule of law that we know it will continue in the country. And so let me just end by saying it would be a mistake to say that the mixed executive was a complete success. By the time the Heritage Foundation wrote its 2025 manifesto, to try to change the theory of the executive branch from a mixed to a unitary. It did so because the mixed executive was creaking. It was showing signs of strain. It was not functioning exactly as we would want it to function. First of all, from the days of Roosevelt until the days of now, the executive branch has exploded enormously to the point where there are now 400, more than 400 separate agencies operating inside the executive branch. All of them with separate programs, all of them with a separate bureaucracy, and all of them with a significant budget. Many of the programs are redundant. Many of the programs could be pared down and be made much more efficient. And under the mixed executive, the way the mixed executive operates, since Congress can lock officials in for fixed terms to run many of those programs, the argument was that the programs were not democratically accountable because the president had no power to remove people with whom he disagreed. And therefore, he could take the position, it's not my fault what the agencies are doing. And the whole theory of democratic government is that you can hold the president accountable for the failures of the executive branch. And if the president could say, look, I'm dealing with a stacked deck here. I can't do anything with the executive branch. First of all, because it's too big, too unwieldy, too resistant to change, and as a matter of law, locked in ways that I can't change it because I can't change the people who are running it. And so that's an argument that I think can't be rejected. There were difficulties with the existing mixed executive that had grown over the years, and reform, I think, was on the table. I mean, serious efforts at reform were, I think, welcome at that point. What's not welcome, at least in my mind, in my eyes, is a kind of blitzkrieg designed to just blow the executive branch up, render it completely under the thumb of the president, with no serious thought and no time to reflect about how exactly we want the thing to be structured, when we should have some insulation from day-to-day politics, and when it's more appropriate to provide for the operation of a more unified, politically accountable executive. So that's the challenge. The challenge is, first, is it just a matter of policy choice to have a unified executive or a mixed executive? Or does the unitary executive violate separation of powers by vesting too much power in a single person? That's the big debate. That's what the Supreme Court is going to have to decide. Whether you're talking about the president's executive order about changing government regulations. Let me give you a quick list. You know it as well as I do because you've been following the papers. But a quick list of what the president has done in attempting to impose this unitary executive. And maybe I'll attempt to suggest what I think creates real separation of powers problems, violations of the separation of powers, and what does not. But before I do that, and I promise I'll do that, but before I do that, I want to remind you that separation of powers is only one of the mechanisms by which the 1787 Constitution protects individual liberty and protects the rule of law. There are three ways that the 1787 Constitution was designed by the founders to be a bulwark of individual freedom and a way to have democracy without having it turn into majoritarian tyranny. The first is federalism. And we don't want to forget about federalism. It's very, very important. The founders set up a federal structure that limited the ability of the national government in Washington to operate too much and to control too much of what goes on in the states. Now, so far, Trump has not attacked federalism with any kind of systematic efforts, the same way he's attacked separation of powers. But he has made two moves, and one more recent move that we really should think about. One, he's moving against the state of Maine in a way that is inconsistent with respect for Maine's federal autonomy. And he's doing it for the reason he does so many other things. He thinks the governor of Maine insulted him a couple of years ago when she called him a bully. And so one of the first things that he did is start retaliatory action against the government of Maine. Now he's threatening to do that to a number of other blue states. And much of his effort now to assert control over local education by insisting upon removing any materials that he finds inappropriate from a diversity standpoint is the beginning of an assault on local autonomy, and we should be watching for it because the federalism protections are fundamentally very, very important. The second basic structure that the 1787 Constitution uses to protect individual freedom is the idea of enumerated rights, the Bill of Rights, the actual laundry list of freedoms that we're supposed to be able to exercise without fear because we're a free people. There has been a sustained attack by the president on the fundamental idea of the First Amendment. And it's almost always retributive. What he's done is he's singled out those people and institutions that he thinks over the years have opposed him or insulted him or some other way annoyed him. And he's moving against them in ways that are designed to prevent their ability to act and organize politically to oppose him. And the most obvious one was when he threw the Associated Press out of the White House the White House briefing room because the Associated Press wouldn't kowtow and call the Gulf of Mexico the Gulf of America in its style manual. But of course, as you know, he's done this in a systematic way to a number of institutions. He started with the law firms, and I'll come back to that in a second. And the law firms have shown a disgraceful tendency to roll over and not fight. I don't know if you guys realize this, but of the 100 largest law firms in the United States, only 8 have signed the brief defending the law firms that Trump has moved against. 4 of the law firms are fighting it in court, and an amicus brief has been prepared and filed by other law firms supporting them. Only 8 of the 100 biggest signed on. So 92 of the biggest law firms in the country are hiding under a rock somewhere or making their own deals with the president. Then, of course, you realize, you know, that he's moved against the universities by conditioning the federal aid to universities on a set of ideologically driven so-called reforms, hiding behind the idea of anti-Semitism in an effort to force the universities to stop being a source of opposition to him. And the recent actions by Harvard are the first time that anybody has fought back systematically on that. In addition, he's moved against the press with a series of libel actions. He has singled out curricula in K-12 that he doesn't like, and he wants it out. And so it's a sustained attack on the idea of a free society in which organized power centers can oppose whoever it is that is exercising significant power at the center. And I think it's an existential threat to the existence of the government. I can't tell you how saddened and disappointed I am at the failure of the large law firms to resist Trump. Um, um, I did a satirical piece about the Westminster Dog Show in 2025, you know, the big dog show at Madison Square Garden, every year. And I've suggested that they open the Westminster Dog Show in 2025 by Trump parading the managing partners of the 20 largest firms around the ring, and they should be wearing diamond-studded dog collars, and they should stop every once in a while and lay down and roll around and do tricks for him. And as soon as the managing partners have finished walking around the ring, then what we'll do is have a group of federal judges enter wearing muzzles, and they'll be paraded around the arena by Supreme Court handlers who have shut them up and rendered them incapable of significantly resisting. And then the opening of the ceremonies will end with a mass feeding of university presidents, all of whom will go out into the middle of the ring and lay down and eat snacks from Trump's hands. Now, that'll tell you how mad I am. I mean, how disappointed I am by the failure of collective action on the part of the parts of the American society that know better and have a responsibility to speak up for our liberties at a time where they're under attack. And my sense is that the tide is turning. My sense is that Harvard, by fighting back, may have put some spine into some other schools to fight back as well. And that although the 100 largest law firms, only 8 of them rallied to the cause of protecting the professionalism and autonomy of the practice of law from government pressure, at least the next tier, 500 of the smaller firms signed on to that amicus brief. And a lovely amicus brief was also prepared on the part of legal academics. And I'm very proud to say that a number of NYU faculty joined me in signing that brief in support. But I don't think we can ignore the fact that while federalism isn't under assault, enumerated rights are. And the enumerated right, the theory that Trump seems to be pursuing, is a theory that says if you dare speak up, I will punish you in some way. I will tie you up in litigation. I will revoke your security clearance. I will pull your federal funding. I will do whatever I can to make life unpleasant for you if you dare speak up. And the risk of that is that you can have rights that still exist under those circumstances, but people are afraid to use them. And so in some sense, it reminds me of the McCarthy period that I lived through as a young boy. I remember how frightened people were to speak up during McCarthy. It didn't matter that the First Amendment was still there. It didn't matter that if they went to court, they'd probably win. The problem was who had enough money to be able to defend themselves. And you never really knew for sure what kind of retribution was going to be enacted or imposed on you that you didn't know about or you couldn't fight. So people kept quiet out of fear. And he's trying to instill that same sense of fear in large segments of the American society. And if we as lawyers have any responsibility at all to the Constitution that we swore to support and defend, if we as lawyers have any duty at all, it's to organize collective response to that so that individuals don't have to stand by themselves in a situation. I'll share an anecdote with you that I don't think very many people know from my own past, past. As all of you guys know, I was an ACLU lawyer for many, many years. And one of my clients back in the old days, in the late 70s and maybe 1980, was Morton Sobel, the third person in the Rosenberg Atom spy trial. The Rosenbergs were executed. Sobel got 30 years. And he was released after 19 years, time off for good behavior, and wanted to give a speech to the Communist Party in Kansas City. And the prison authorities, he was still technically on parole for the next 11 years, wouldn't allow him to leave the Southern District of New York to give the speech in Kansas City on the grounds that it would be bad for him. The last time he had associated with communists, he had gotten into trouble, and so they didn't want him to associate with communists anymore. He came to me and I said, no, that's a violation of your free speech rights. You have a right to go to Kansas City and give a talk. You're out of jail. You're entitled to the protection of the First Amendment, even though you wouldn't have probably given it to anybody else, but you're entitled to it. And so I went to court to attempt to lift the ban on Sobel's giving the speech, and I eventually won. He did give his speech to the party in Kansas City, but during the litigation, a very, very powerful judge on the Second Circuit, Irving Kaufman, who had presided over the Rosenberg case as a trial judge and had sentenced them to death. And then he'd gone on to the Second Circuit. And he was, in 1980, he was a very powerful man. He called the ACLU and he told the ACLU that he thought it was a mistake to allow a young lawyer like me to become involved with Morton Sobel. And he insisted that the ACLU remove me from the case. Ostensibly, it was for my best interest. He was worried in my best interest. Of course, what he was worried about was Sobel getting any kind of effective representation. And to the credit of the folks at the ACLU, they responded very vigorously to Kaufman and said, if you ever try anything like that again, we'll go to the authorities, and you mustn't ever attempt to interfere with a pending case that way. But most important, they didn't tell me. They shielded me from the pressures and of Kaufman's implied threat that if I stayed on that case, it wouldn't be good for my career. They didn't tell me. They simply said to Kaufman, get away. Don't you dare do anything like this again. And then I finished the case, and only after the case was over did they tell me that about this. And I thought to myself, this was wonderful. This shielded me. Who knows? I mean, we're all flawed individuals. Who knows how we respond to individual threats when they're made to us in settings where we have some vulnerability. And I never had to put myself to that test because there was a collective response that shielded me from the pressure and allowed me to do my job free of that, of having to ever look into my heart and see how brave I was. Well, we owe other folks that same protection. We have to begin to organize collectively and not leave people out there to be taken down one by one. This is a trope that you've heard in seventh grade civics, but it's worth repeating. At the end of the Constitutional Convention, I'm sorry, at the end of the Declaration of Independence, when the Declaration was being signed, Benjamin Franklin turned to the people in the hall and said, "Congratulations, we've done a good thing, but we'd better all hang together now, or else we will certainly hang separately." And that's the case now. We have to hang together, or else we risk hanging separately. So now let me shift over to the separation of powers and quickly do some separation of powers with you. I think let's list some things that he did, and I'll try to give you my sense about whether it violated separation of powers or not. The first thing you remember that Trump did when he came in was he fired the 12 inspector generals at the various agencies, whose job was to kind of make sure that the rule of law was being respected within those agencies. Then he removed the chairman of the Joint Chiefs of Staff and redid the military hierarchy to put loyalists in place. And then he removed the head of every single law enforcement agency, the FBI, the various federal agencies that carry guns, so that at the end of that spate of reorganization, he had personal control over every element of the federal government that carried guns, that had formal coercive power. Now, I found that terrifying, but it's not a violation of the separation of powers, because that's what the president does. The president is the head of the executive branch and commander-in-chief of the armed forces, and he can move the military hierarchy around. He does get to a point who the head of the FBI is, and he does get to decide what the law enforcement agencies of the United States do. That's what an executive branch does. And it would be a mistake, I think, for us, because we're afraid of Trump, for us to try to complicate that hierarchical structure. It's a hierarchical structure that that privileges efficiency and speed and democratic accountability. And I think that's a good idea. But he then tried to go further, as you remember. He then asserted the power to remove officials who were serving in positions where Congress had given them fixed terms and had tried in some of the agencies to have multiple officials that would have bipartisan control of the agencies, like the National Labor Relations Board. The position of the unitary executive is that the president has to have untrammeled power, just like his power over the commander-in-chief of the military. He has to have untrammeled power over who are the heads of the various agencies, even when Congress has tried to structure those agencies so that the heads of the agencies have some insulation from day-to-day power politics. Now, when I taught you guys Fev courts a long time ago, the answer was that the Supreme Court had clearly said that you cannot remove an agency head that has been locked into place by Congress for a fixed set of terms. You can remove them for cause, but you can't remove them because you're politically annoyed at them. That's changed. The Supreme Court has now held that agencies headed by a single person fall within the unitary executive, and the president can remove them at will, regardless of the of Congress's desire to lock them into place for a fixed term. What's pending before the court now is whether multiple agencies that are headed by multiple people, because Congress wanted a more bipartisan approach to the administration, whether they're covered by the unitary executive. And as many of you know, there's a 1935 case, Humphrey's Executor, that affirms the existence of the mixed executive with respect to multiple agencies. And the Supreme Court is now considering whether to reverse Humphrey's Executor and impose a unitary executive on who are the heads, multiple heads of these agencies. I think that's terrible, terrible policy. Trying to give those agencies some autonomy, some breathing space, so that you can use expertise and not just politics to be able to run some of these important and difficult programs is a very valuable setting. But it's going to be up to the Supreme Court to say whether or not it's a matter of a constitutional law, whether it violates separation of powers to give the president that kind of control. So that the last one is whether the president can can simply dismantle congressional agencies that Congress has set up, and refuse to spend money that Congress has appropriated. Once again, the Heritage Foundation folks argue that that's a violation of the unitary executive. My own sense is that it is unconstitutional for the president to refuse to spend money appropriated by Congress. that fails to recognize Congress's role in the separation of powers. Remember, Congress makes the law, the president enforces the law, and the courts resolve disputes about the law. So if the president simply ignores what Congress does and won't spend the money that they appropriate and won't permit the programs that they have created to continue in existence, then what the president is doing is spitting in Congress's eye and violating separation of powers. And I believe that's what the Supreme Court's going to hold also. That's the existing law. The last thing I'll say, because I want to leave some time for questions, the last thing I'll say is the president's relationship with the courts. Now, this is hugely impossible. You guys remember the first time you read Marbury versus Madison. I hope you remember it because there's going to be a quiz at the end of this on exactly that. But the first time that you read Marbury versus Madison and you realized that judicial review wasn't in the Constitution and that judicial review was really a remarkably brilliant power grab by John Marshall back in 1803, and that so much of what we take for granted as the touchstone of the American government, the ability of courts to function as the independent arbiter, is really based on the acceptance of Marbury versus Madison as a binding precedent. I see no effort to overturn Marbury, but what I do see is nibbling at the edges, arguing that lower court judges don't have to be listened to, arguing that pressure can be put on the Supreme Court to move, arguing that in certain areas that involve national security and immigration, even if the Supreme Court says something, the president may have inherent power to ignore it. I see real challenges to the role of courts in preserving the separation of powers. And again, as lawyers, it seems to me all of us owe a duty to rally to the defense of the courts, whether or not you agree with what they've said. Because if we're going to have a principled separation of powers, it has to apply to things that we disagree with, just as it applies to things that we agree with. So I think we have to say, look, I'm nervous about single judge injunctions. Single judge injunctions paralyzed the Biden efforts to do some decent things. And I hated single judge injunctions because what they were doing was picking a judge down in Texas, and that judge froze the whole program nationally. Well, but I didn't like it, but we abided by it. And so we may want to change how much power a lower court judge has to issue nationwide injunctions, but that's something for Congress to do. It seems to me now the question is we have to rally to the defense of the judiciary itself and insist that the judiciary play its role as the third element in the separation of powers, as the agency that can answer the questions about what the law is and how it applies. So having confused you, I'm sure, let me open the floor to some questions. I've not done this before technologically, so who knows if I'm going to electrocute myself now, but I'm going to try to open the chat and see the questions.
Professor, we're happy to read out some questions to you from the chat. And please, anyone who has questions, please enter them in the Q&A box. But we can start with, does Article 2 of the Constitution contain any reference to executive orders? And if not, is their status different from any interoffice memoranda?
Great question. During the first 100 days of the Roosevelt presidency, he issued 99 executive orders. And that was the world's record in executive orders up until now. In the first 92 days of the Trump administration, he issued 130 executive orders. Now, what's an executive order? All an executive order is a memo from the desk of the president saying this is what I am pronouncing. Now, if it's something the Constitution says nothing about them. If it's something that he has the inherent power to do, like the inherent power to recognize a foreign power, a foreign government is legitimate, then an executive order has real force. It is the articulation of the president's view, and the president has the power to do it. But if it's something that the Congress or the administrative agencies have the power to do, then all an executive order is an announcement of the president's wish that it happens. And that wish doesn't necessarily have the force of law. If he doesn't have power to act in that situation, then executive order is just a soap bubble. And if what he's doing is telling the Food and Drug Administration or the Justice Department that they should be changing course and doing something, that's something that they then have to do, and their actions will have the force of law. But the executive order will not. So I think people overstate the importance of executive orders. They're a great barometer that measures the intensity of what the president is doing, but they themselves rarely have the force of law. Okay, next.
Thank you. Several bar associations in the New York City are hosting a rule of law rally. And the New York Bar City Association has also organized dozens of bar associations across the country to submit amicus briefs on behalf of the lawyers involved in the Perkins Coie, WilmerHale, et cetera cases. Do you see bar associations as being a vehicle to help lawyers stand up against these incursions into the constitutional rights being violated?
Absolutely. I mean, I think that's what, I mean, one of the things I was so disappointed at is that it's taken them this long. God bless them. Many of them are arriving, and they're doing very good work now. But the whole purpose of a bar association is not to leave lawyers individually vulnerable to have to stand up on their own and defend important values and settings where it's difficult for them to do so. A bar association is it's a collective defense mechanism. And of course, bar associations should rally to the rule of law and rally to lawyers when those lawyers are being pressured not to live up to what an American law firm should live up to as an independent source of legal advice about what the law is and what the government is allowed to do. My wife and I went to, we're out here in Palo Alto in the sun in our mid-80s, but we went to a demonstration in downtown Palo Alto last week, and guess what? We dusted off the same sign that we held in 1968 that said, "Silence is not patriotism." And silence now is not patriotism. So I'm delighted to see that the bar associations are finally getting on board. I'm sorry to see that it's not the American Bar Association. It's the local city. It's not the state bar associations. It's the local city bar associations that are leading the way. I wish the national and state bar associations would get on board.
Excellent. A few folks have asked some sort of version of a question. If Trump ignores a court order and the Supreme Court tells him to obey and then he refuses, what's the remedy? Send the federal marshals?
Well, that's a hard question. So first of all, the federal marshals work for the Justice Department. The judiciary doesn't have its own police force, and it doesn't have any formal way of enforcing its orders. It can hold contempt proceedings, both civil and criminal contempt. If it wants to do criminal contempt, usually the Justice Department is the prosecutor, and if the Justice Department doesn't prosecute, existing rules allow a judge to appoint an independent prosecutor. There's some question about whether that would be constitutional, but the rules provide for it. And so a judge could move forward with criminal contempt. The trouble is, criminal contempt is pardonable. So the president could pardon a criminal contempt. A civil contempt is not pardonable, but the civil contempt is it has far fewer sanctions. So the truth is, and this has always been so, the only way to defend judicial power is through political support. My sense is, if the last poll that I saw said that if the president defied the Supreme Court, 87% of the country felt that he would have done something fundamentally offensive to American values. And 87% of the country, you can't get 87% of the country to agree that the sun rises in the morning. But 87% of the country said that if he defied the Supreme Court, it would be a terrible thing and they would punish him at the polls. And that's ultimately the protection that the courts have. We are the protection that the courts have, an aroused people that will not allow the erosion of those values. If we sit by passively while those values disappear, there are not formal structures where some deus ex machina drops down and fixes it for us. It's up to us. And in crisis times like these, political organization to defend the values we care about is the only enduring protection that they really have.
Next question. What is the interplay between the vesting clause in Article 2 and the take care clause? It seems to me that the right wing is constantly citing the former to justify Trump while ignoring the latter.
I think that's right. I mean, the take care clause there's no doubt that the president is the sole repository of executive power, and that the take care clause tells him that he is supposed to carry out the laws of the United States with respect for the idea of the rule of law and the role of different institutions in carrying it out. The right is using the take care clause and the executive clause as a kind of warrant, a kind of permission for the president to ignore anything except the things that he agrees with. And it always seemed to me that both being an executive and taking care that the law be faithfully executed was a grant of important power, but not a grant of absolute power. And that, I think, is what we have to fight back on. And I think that's what, maybe I'm romantic, but I think the Supreme Court is not going to permit the imposition of such a unitary executive.
So we have a question. Isn't it true that English common law and the Federalist Papers and early Supreme Court decisions against states showed that judicial power to declare unconstitutionality was an accepted norm, though not frequently imposed?
Sure. There's no. It's a great observation. It wasn't like judicial review didn't exist at the beginning of the country. It was usually, though, the power for judicial review was mentioned in the Constitution, that there was some textual support for it. The difficulty with the judicial review in the American Constitution is there's no formal textual support for it. When you read Marshall's opinion in Marbury, you see that he infers it as a necessity. Saying, look, if we have to decide these cases, what are we supposed to do? If we decide them, then we have to exercise judicial review because it's the inevitable consequence of resolving a case or controversy. Now, of course, there's lots of answers to that. One answer is, sure, it allows you to do it for the judicial branch, but it doesn't allow you to tell the executive branch how it reads the Constitution. I think that's a terrible argument, and I fight against it all the time, but it's a plausible argument inside the text. I don't want you to understand when I said that that judicial review was not formally in the Constitution, that I'm not a supporter of it. I think it is an incredibly important element of the American system. The difficulty is that people who argue against it at least have a plausible argument that where's the textual support for it.
Next question. What would you say are some ways that ordinary citizens can fight against federal incursions on states' rights when it comes to Trump's demands to states and the private sector around DEI and his very damaging executive orders focus on dismantling DEI?
Yeah, a great question. You saw, I think it was yesterday, that there was a very encouraging decision striking down some of these DEI mechanisms, and people are beginning to see that they're not just assaults on individual First Amendment freedoms. They're not just efforts to tell you how to think. They're fundamental assaults on the idea that education, curriculum for education, is a state and local matter, and not a national matter to be imposed. And so I think both as a matter of federalism and as a matter of individual rights, the ban on DEI is a very dangerous thing, and courts are beginning to move against it. There are a number of things that individuals can do. And again, at the risk of sounding romantic, there'll be a demonstration on your corner next week somewhere. Go to it. Tell your friends to go to it. Make sure that your kids understand it. Make sure that everybody that you know is registered to vote. Make sure that everybody you know is ready to vote. 2026 is going to be a crucial set of elections. And unless people who care about the values organize themselves politically, there's no magic answer to any of this. So organizing politically is enormously important. Letting the local education authorities know that you respect and care about what they're doing, and that you don't see them as enemies, and that you do support the ability of teachers to try to use their professional best judgment about how to educate our children in public schools is enormously important. Making sure that you vote when your local school board budget comes up. It's embarrassing. Local school board budgets often are voted on by 8 to 10 to 15% of the eligible electorate. And that allows the extremists on both sides to dominate the elections. The school board budgets are important, and you should watch for them. And when they come up, you vote on them because that's part of your duties as citizens. There are things that individuals can do. But most importantly, I think it's to stand up and make your voice heard about the importance of these issues.
Next one here is a speaker asks, do I understand you correctly that before FDR, we had a solitary versus mixed executive?
No, before FDR, there was a non-existent executive. If you go back, and look at what the executive did, the executive gets created in 1789 in the first, when Congress, the first Congress to meet under the new Constitution, had to organize the government. And so it organized the various cabinet positions that the president wanted to have. And the very first vote they had that was of real significance was a question of whether or not the cabinet secretaries, that they had to be confirmed by Congress. So Congress had a role in who they were going to be. The question is, could the president remove them without the permission of Congress? Now, there's nothing in the Constitution that says anything one way or another on that. But the first Congress in 1789 voted that the president should have the unilateral power to remove his cabinet secretaries if he wished. He didn't have to ask permission from Congress. And that set up the beginnings of what would be a kind of unitary executive branch, but only as to the cabinets. Now, for a long time, that's all there were. It wasn't until the Civil War that you had any significant expansion of the federal executive. And then it was only on a temporary basis to create the mechanisms needed to fight the war. And then it wasn't until the First World War until we ginned up the executive branch again, but it was quiescent. And if you took a look at what the executive branch looked like in 1928, it was small. I mean, there were very few people in there, and they weren't doing very much. They were doing a little bit, but it was only after 1932 that it exploded into anything like what we have now. And of course, that then went through the Second World War and the Cold War. And so that was a dynamic for the continued expansion of the executive branch, because if you're fighting a war for national survival, you're going to have a larger executive branch. If you're in the midst of an existential struggle with communism, in which atomic weapons are a possibility, you're going to have a very, very powerful executive branch. And it wasn't until the Berlin Wall went down in 1989 that people then began to question whether the executive branch had gotten too big and too unwieldy. And so the arguments for reform of the executive branch really date from the end of the Cold War.
Thank you, Professor. I think that's about time for us.
Oh, all right. Well, that's too bad. If anybody who didn't get a chance to answer, ask the question, I'll come visit you in your home tonight. You just send me the address and I'll be there. You remember, if you didn't, if you missed an assignment in class, I would come visit you in your apartment. So I'm prepared to continue that. But I wish, if you email the questions, I'm bert.newborn@nyu.edu. I promise I'll respond to them. Any of you that have questions, by all means, you can light up my lonely life here in Palo Alto with some questions, and I'll be very, very happy to answer them. But I enjoyed talking to you this morning, and welcome back, and cherish NYU as a place that I hope trains you well and that you feel proudly about now. Bye-bye.